A video recording of former President Donald Trump's deposition in the civil rape case against him was released today.
The video shows the former president answering questions about writer Elizabeth Jean Carroll, who accuses Trump of raping her in the mid-90s. A segment of the hours-long deposition was recorded last October. KTLA's Sandra Mitchell joins us live in studio with the latest on the case and what it could mean for the former president. Sandy.
Yeah, Cher, this really is a stunning video with an attorney grilling Trump, the former president, actually blasting the rape and defamation accusations in this civil case against him.
It's the most ridiculous, disgusting story. It was just made up.
Tonight, a historic showdown in a New York courtroom has led to an unprecedented legal command. A federal judge has issued an immediate arrest order for a sitting president following allegations of a conspiracy to obstruct justice. We have the internal memos, the recorded calls, and the deposition transcripts that brought us to this moment. Let's play this clip.
She's accusing me of raping her. The worst thing you can do, the worst charge. And you know it's not true too. You're a political operative also. You're a disgrace.
Trump has not put on a defense or called any witnesses in the case, and now it will be up to the jury to decide who they believe in a story that goes back 27 years.
It may give the jury pause to say, why are we here now? Why didn't she file a police report at the time? How come it's taken decades for her to come forward?
Donald Trump has said he will not take the stand, but now the judge has given him until Sunday night to change his mind if he wants. Closing arguments set to begin Monday, and then the case could go to the jury on Tuesday.
Imagine walking into a federal courtroom. It is a place of high ceilings, heavy wood, and a silence that usually commands respect. On this day, the atmosphere changed. A federal judge, wearing the traditional black robes, sat on the bench and was handed a stack of documents. These were not just standard filings, they were phone records, they were internal emails, they were memos from the legal team of Donald Trump. What those papers revealed shifted the entire trajectory of the proceedings. The judge began reading through evidence that suggested a direct attempt to deceive the court. Prosecutors presented receipts showing that the legal team may have provided false information regarding whether a court-ordered deposition had actually taken place. This was not a minor technicality. This was an allegation that the lawyers had straight up lied to the court about their client's compliance. As the judge reviewed the documents line by line, the tension in the room reached a breaking point. The court then heard something even more striking, a recorded phone call played in open court. On this recording, the former president was allegedly heard instructing his lawyers to say whatever was necessary to delay the legal process. The judge's reaction was immediate and definitive. He did not scream, but his ruling came down with the weight of a hammer. The judge ruled that the contempt of court was willful. He stated that there was an active effort to undermine the authority of the judicial system. He called it an obstruction conspiracy. Then came the order that many thought they would never hear in American history. The judge issued an immediate arrest order, effective immediately. He directed U.S. Marshals to take Donald Trump into custody without any further delay. This development strikes at the very heart of the American democratic system. It raises a question that has long been a matter of academic debate, but is now a concrete reality. Can a sitting president be arrested? The judge addressed this directly. He ruled that Secret Service protection does not extend to shielding a president from a lawful arrest. Furthermore, the judge warned that if Secret Service agents attempted to interfere with the U.S. Marshals, those agents themselves could be held in contempt of court. This is the kind of drama usually reserved for television, but it is happening in a real federal court. It represents a moment where the foundations of the legal system are being tested. The evidence brought forward, the phone records, the internal memos, and that recorded call, paints a picture of a legal strategy focused on delay and deception. Now that strategy has hit a wall that it cannot simply break through. While this immediate arrest order is the most urgent development, it is part of a much larger narrative involving a writer named E. Jean Carroll. To understand how we got to this point of total legal breakdown, we have to go back to the origins of her case. E. Jean Carroll is a columnist who accused Donald Trump of a serious assault in the mid-1990s. She alleged that the encounter took place in a dressing room at the luxury department store Bergdorf Goodman in Manhattan. For years, the public heard denials, but eventually the case reached a jury. In May 2023, a jury returned a unanimous verdict. They found Donald Trump liable for sexual abuse and defamation. They awarded E. Jean Carroll $5 million in damages. Trump's legal team immediately tried to have this award reduced or the verdict overturned, arguing it was excessive. However, Judge Lewis A. Kaplan upheld the verdict in July 2023. The judge's written opinion is a key piece of the public record. Trump's lawyers had argued that because the jury did not find him liable for rape under the narrow technical definition of New York law, the damages for sexual assault should be lower. But Judge Kaplan disagreed. He wrote that the jury's verdict was almost entirely in favor of Carroll. The judge explained a very specific distinction in New York law at that time. Under the state's penal law, rape was defined very narrowly as vaginal penetration by a penis. If the penetration involved fingers or other objects, the law labeled it sexual abuse instead. Judge Kaplan noted that this definition was much narrower than how the word is used in everyday conversation or even in modern dictionaries. The judge was very clear in his assessment of the evidence. He wrote that the proof established, and the jury implicitly found, that the defendant had deliberately and forcibly penetrated Ms. Carroll's vagina with his fingers. He stated that the verdict did not mean Carroll failed to prove she was raped in the way most people understand that word. In fact, he wrote that the jury found he did exactly that. This case has had consequences that go beyond the courtroom. Because of the technicalities that Judge Kaplan mentioned, the gray areas that defendants can exploit, the state of New York actually changed its laws. In January 2024, Governor Kathy Hochul signed a bill to expand the legal definition of rape. The law now includes non-consensual anal, oral, and vaginal sexual contact, regardless of what is used to commit the act. During the signing ceremony, the governor specifically pointed to E. Jean Carroll's case as a reason for the change. She said that physical technicalities should not be allowed to confuse jurors or humiliate survivors. Throughout this entire legal saga, the denials from the former president have been consistent and public. To understand the mindset behind these denials, we have to look at the deposition he gave in October 2022. This deposition took place at Mar-a-Lago in Florida. It was a high-stakes moment where he had to answer questions under oath. During that deposition, a central theme was his claim that he did not know who E. Jean Carroll was. He repeatedly stated, "I have no idea who this woman is." He called her story a complete con job and a big fat hoax. He suggested that she was a sick person or a nut job who made up the story to sell a book. He even went as far as to suggest that her lawyer was a political operative. But one specific moment in that deposition has become famous for undermining his primary defense. For years, the former president's most common response to the allegation was to say, "She's not my type." He told this to reporters in the Oval Office in 2019, and he repeated it in his Truth Social posts in 2022. During the deposition, he confirmed that when he said she wasn't his type, he meant physically. However, while he was being questioned by Carroll's lawyer, Roberta Kaplan, he was shown a black and white photograph. The photo showed him at a charity event in the late 1980s or early 1990s. In the photo, he is talking to a woman. When asked to identify the woman in the picture, he pointed to her and said, "That's Marla." He was referring to his second wife, Marla Maples. His own lawyer had to step in and correct him, saying, "No, that's Carroll." This created a significant contradiction. If his defense was that the accuser was not his type and that he would never be attracted to her, the fact that he confused her with his own wife was a major factual problem for his narrative. The deposition also explored his history of making similar comments about other women who have accused him of misconduct. For example, he was asked about Natasha Stoynoff, a writer for People magazine who alleged he was aggressive with her in 2005. His response to her was similar to his response to Carroll. He told a crowd at a campaign event to look at her and suggested that her claims were impossible because of her appearance. He used the same logic when discussing Jessica Leeds, who accused him of groping her on an airplane in the 1980s. In a video from a 2016 campaign event, he told the audience, "Believe me, she would not be my first choice." When questioned about this in the deposition, he admitted that he was referring to her physical looks. He argued that when people insult him with made-up stories, he has a right to be insulting in return. The legal team also brought up the Access Hollywood tape, which was recorded in 2005. In that video, he is heard saying that when you are a star, women let you do anything, including grabbing them by their private parts. When asked about these comments during the deposition, he did not deny saying them. Instead, he called it locker room talk. He then went a step further, stating that, historically, that's true with stars. He said this had been the case for the last million years. This history of public statements is exactly what led to the defamation portion of the E. Jean Carroll Carroll case. When he was president, he released statements through the White House press office calling her claims fake news and a disgrace. Even years later, after he left office, he continued to post about her on his social media platform, Truth Social. He testified that he wrote these Truth Social posts himself. In one post from October 2022, he called the case a complete con job and claimed the legal system in New York was a broken disgrace. He used the word hoax to describe the case, a word he admitted to using hundreds of times to describe various investigations into his conduct, including the Russia investigation and the Mueller report. One of the more unusual parts of his 2022 statement was his use of the word swooned. He wrote that Carroll claimed he swooned her within minutes of meeting her. When the lawyer pointed out that swoon usually means to faint with emotion, he disagreed. He testified that he used the word as a nicer substitute for a vulgar term for sexual intercourse because he thought using the other word would be inappropriate. He also claimed during the deposition that in her interview with Anderson Cooper, E. Jean Carroll had said that rape was sexy. However, when pressed on this, he admitted he hadn't watched the interview in a while and told the lawyer she should watch the interview herself. He insisted that Carroll was a mentally sick person and a liar. Despite these intense denials, the jury's decision remained firm, and the legal consequences began to mount. After the initial $5 million verdict, E. Jean Carroll added more claims to her lawsuit based on the comments he made after the trial. She sought an additional $10 million in damages. Eventually, a second trial resulted in an even larger order for him to pay her $83.3 million for defamation. Now, all of these threads, the Carroll verdict, the deposition admissions, and the history of public denials have culminated in this current crisis in the federal courtroom. The immediate arrest order isn't just about one case. It is about the documented pattern of how the former president and his legal team have interacted with the court system. For a long time, the strategy appeared to be one of push, delay, and appeal. By filing endless motions and challenging every court order, they were often able to slow down the wheels of justice. But this particular federal judge decided that the delays had reached a limit. When the evidence showed that the court had been misled, not just by accident, but as part of a coordinated strategy, the judge took the most extreme step available to him. The implications of this are staggering. We are seeing a direct physical confrontation between two different branches of the federal government. On one side, you have the U.S. Marshals, who are officers of the court. Their job is to carry out the orders of a federal judge. On the other side, you have the Secret Service, whose mission is to protect the former president at all costs. If the marshals show up to execute the arrest warrant, what does the Secret Service do? Do they follow their training to protect their subject from a physical threat? Or do they follow the judge's ruling that they must stand aside for a lawful arrest? This is not a hypothetical scenario anymore. The arrest order is effective immediately. This moment is a test of the credibility of the entire American legal system. If the arrest order is carried out, it sends a clear message that no one, regardless of their status or power, is above the law. It proves that the courts have the actual power to enforce their own rules, even against the most powerful people in the country. However, if the order is blocked, whether through political pressure, Secret Service interference, or further legal maneuvering, it sends the opposite message. It would suggest that court orders are merely suggestions for the powerful and that the judicial branch cannot truly check the power of the executive. The evidence the judge relied on is documented. The phone records exist. The emails exist. The recorded call where the instruction to lie was allegedly given has been played in a court of law. The judge looked at all of this and decided that the situation could not wait for more appeals or more procedural games. He decided that the rule of law had to be defended right now. This is the opening act of a new chapter in American history. It is a moment where the phrase "no one is above the law" is being put to the ultimate practical test. We are moving past theories and debates and into a reality where federal agents may be forced to choose between competing orders from different parts of the government. As we watch this unfold, it is important to remember the facts that brought us here. It started with a specific accusation of assault in a department store. It moved through a civil trial where a jury found that a forcible penetration had indeed occurred. It involved a deposition where the defendant confused his accuser with his ex-wife. And it has ended, for now, with a federal judge concluding that the legal system itself was being intentionally undermined. The fallout from this will likely reshape American politics and law for decades. Whether it results in an actual period of custody or an even larger constitutional showdown, the fact that a federal judge felt compelled to issue such an order is a historic milestone. It marks the point where the legal system decided it would no longer be a bystander to its own obstruction. We are in uncharted territory. There is no map for how a country handles the arrest of a sitting president on charges of obstructing a federal court. We don't know how the Secret Service will react in the coming hours. We don't know if the U.S. Marshals will be able to complete their mission. But we do know that the order has been signed, the evidence has been presented, and the silence of the courtroom has been replaced by a national crisis. The next few days will determine if the judicial branch can hold its ground. The eyes of the country, and indeed the world, are now on those U.S. Marshals and the Secret Service agents who stand between them and the former president. This is the moment where we find out if the institutions of American democracy are strong enough to hold, or if they will finally shatter under the pressure of this unprecedented conflict. As this story continues to develop, the focus will remain on the documents and the evidence. The phone records and the recordings will continue to be the foundation of the case against the legal team. And the testimony from the E. Carroll deposition will continue to be the shadow that hangs over every denial. We will be following every update from the courthouse and every move by federal law enforcement. This is not just about one man or one case. It is about the very idea that a court's word is final. It is about the principle that the truth matters, especially when you are under oath, and especially when you are the president. The judge has made his move. The Marshals have their orders. The Secret Service has been warned. Now, the rest of the country waits to see what happens when the law finally stops asking and starts acting. This is a story that began in a dressing room 30 years ago and has led us to the brink of a constitutional breaking point. It is factual, it is documented, and it is happening right now. Stay with us as we continue to track this historic development. We will bring you the latest rulings, the latest evidence, and the latest reactions as the United States navigates this unprecedented legal storm. The rule of law is on the line, and the outcome will define the future of the American presidency.